And I'm very excited to introduce our final moderator for the afternoon, Todd Eddins, who is a justice on the Hawaii Supreme Court. And he is going to be hosting us for this program next year, right? Should we all hold this in Hawaii? What do you think?
A little farther.
You will have an unreal turnout, Donald.
Yes, yes. Well, one of these days. And by the way, you can go to masonlec.org if you'd like to donate in order to help us fund a trip to Hawaii for all of the judges. But more seriously, we are also grateful that Todd is, and Justice Eddins has joined our Judicial Education Program Advisory Board as well. So thank you for agreeing to serve on that and to serve on this panel as our final moderator of the day. The floor is yours.
Aloha. All right. Much appreciation to Law and Economic Center and Donald and his team. This is just another spectacular, well-organized, stimulating symposium. And those of you who have been to these before, I think can appreciate that. So once again, thank you. And also on behalf of our panel here, we also want to thank the LSC for slotting us in the coveted Session 8 position as travel plans are dancing in everyone's heads. But I think that was intentional because we have a really, really great panel here and wonderful topic, and I'll introduce our panelists. On my far right, your left, is Tiffany Aguiar. She comes from Orange County, so she thought she flew the furthest here to get here, but that was me and my friend Wes Porter from our Federal District Court. Tiffany is with Crowell and Mooring. She's a litigator. She represents clients in investigations by state attorney generals by the FTC as well. Next to her is Karen Harned. Karen is the president of Harned Strategies. That's a legal regulatory public affairs consulting firm. And for 20 years, she was the executive director of the National Federation of Independent Businesses. She started that from the ground floor. Next to her is Christine Hines. She's the senior policy director of the National Association of Consumer Advocates. She advocates before federal agencies and Congress on consumer protection issues. And to my immediate right is Douglas McNamara. He is with Cohen Milstein, and he litigates complex litigation, mainly class action lawsuits against consumer service providers like banks, insurers, and credit card companies. So we're going to kick-start it with some remarks from Tiffany. So take it away.
Hi, everyone. Can you hear me all right? Yes. Great. I'd like to note that I'm probably the most junior person on the panel, but I printed out my talking points. I found a printer. Really, Emily helped me find a printer this morning. So I think that just goes to show that we can all find commonality despite our potentially generational differences. But thank you so much for the introduction, and thank you for allowing me the time to be here. I'm honored, and I'm really excited for our discussion. So it's my understanding that you all have already heard about artificial intelligence sort of throughout other panels, but some of us would like to sort of provide that perspective from the consumer protection, regulatory enforcement side of things as well. So I'll get started here. Artificial intelligence has moved rapidly from an emerging technology to a fixture in everyday life. Courts, like regulators, are now seeing disputes involving AI in consumer products, financial services, healthcare, and even political speech. So at the state level, attorneys general are increasingly stepping in to ensure that the promises and risks of AI are managed within existing consumer protection frameworks. These developments have major implications for UDAP law, unfair and deceptive acts or practices, just to level set on what UDAP stands for, which remain the backbone of state consumer enforcement. So my remarks will cover the following main points. First is federal inaction to regulate AI in the state of and the rise of states to do so. Attorneys general using existing UDAP authority to keep AI use in check. Expanding the scope of the UDAP statutes to specifically contemplate AI. We'll drill down a little bit on the substantive areas of concern, and then we'll highlight some practical implications for the courts as well. So again, apologies if this has already been stated, but just to level set, when we talk about AI, I think it's important to note no one really knows what AI means when you say it. It can mean a number of different things. And so whenever you start a conversation on AI, you always have to follow it up with questions on, okay, what exactly are you speaking of? What is the functionality? What's the power? AI exists on a spectrum, like many things. And so there are simple task AI or specific task AI tools that have been around for decades, right? AI is not something that evolved in the last 3 to 5 years. And then what we have on the other end is deep learning models that take into account a number of data points and really evolve its learning by taking in more and more information. So for the purposes of my sort of points, we'll be talking about AI on both ends of the spectrum and everything in between. But I just want to sort of note that, is that there is no one definition of artificial intelligence. And artificial intelligence has been in our lives for a while. And in some instances, also speaking from maybe the private client perspective, many businesses that I deal with don't fully understand how they are even utilizing AI, how their employees are utilizing AI. So there's a bit of a disconnect, too, when it comes to sort of breaking UDAP laws on the AI front, because businesses are not fully comprehending how their employees are even using it. So that sets the stage just a little bit on that. So first, we'll start with federal inaction to regulate AI and the rise of states to do so. So things are interesting right now. At the federal level, substantive AI legislation has stalled. The current administration has emphasized deregulation and innovation, emphasized deregulation and emphasized innovation, leaving little in the way of new consumer-facing protections. So just 4 days ago, actually, the White House issued a request for information from the public on federal laws, rules, and policies that unnecessarily hinder the development and deployment of AI. So if I'm looking into my crystal ball a bit, what we have seen are, the Democratic states have been responding pretty strongly to our current administration. And so this will likely lead, in sort of my mind, to even stronger regulations on the Democratic side if we continue to see sort of a deregulation of AI with the current administration. So this is, again, continuing to evolve. In that context, states have become laboratories of AI regulation. So we're starting to see the patchwork develop and evolve. In 2024 alone, at least 45 states introduced AI bills covering issues like deepfakes, election security, and watermarking of AI-generated content. By mid-2025, more than 1,000 bills have been filed nationwide regulating AI in various contexts. So some of these AI bills relate to an intent to update a state's UDAP laws. Some do not. Some are specific and separate from UDAP laws. But like many other areas of the law, when a consumer protection action is filed in court, the claims are often asserted under a UDAP law or statute in addition to various other states and sometimes even federal laws as well. So I think for all you here, one key takeaway is that the consumer protection cases related to AI coming before you may look a little different than past consumer protection cases for traditional unfair or deceptive acts or practices. Since the UDAP statutes in these cases will most likely not specify or specifically address AI activity yet, with the exception of a few states. For instance, Pennsylvania and Utah recently are working on specifically incorporating AI into their UDAP statute. Additional analysis on your part may be needed to ensure the law is applicable. Generally speaking, if you do something that's deceptive or unfair without AI, if you do it with AI, it will continue to be unfair and continue to be deceptive. So that line, that thread will probably continue, but what we are seeing are some states are specifically calling out AI and some states are not in their UDAP statutes. So that'll continue to sort of evolve. So in addition, these UDAP claims will likely be brought with a whole new host of new state statutes specifically regulating certain AI actions. Those are some of the 1,000 new statutes or bills that have been introduced that I mentioned earlier. So not only will we see novel AI applications to age-old UDAP laws, particularly on the question of damages, but you will also have sort of the reckoning, the reconciling of these new lacking precedent state laws on AI specifically. So you'll see the merging of those two issues and having to grapple with damages and obviously not doubling up on recovery and things like that. So, and with any sort of patchwork of laws like we see here where there is no overarching federal umbrella law, you're going to come into conflict of law questions as well as preemption questions. Preemption, most likely on the federal level, may be faced with the FCC There have been some arguments on that front, but also sort of conflict of law issues between states as well. So sort of the next major point are attorneys general using existing UDAP authority to hold companies accountable, as well as other business guidance published by AGs. So, like I mentioned, AGs are not waiting for new specific AI statutes to speak on how AI should and shouldn't be used. Instead, they're applying their existing laws. Some states, like for instance, Oregon and Massachusetts, the state attorneys general there have issued legal advisories or legal warnings to businesses stating that their UDAP statute as drafted applies to AI point blank. And they're really actually helpful. They're about 4 to 5 pages each, and they kind of list some specific activities that they consider to be nefarious. And so they're just kind of helpful resources to review to understand sort of where these states are coming from. In addition, New Jersey's AG launched a civil rights and technology initiative tying algorithmic discrimination directly to its law against discrimination. So again, AI discriminatory algorithmic practices being tied to UDAP type actions. And then in Texas, semi-recently, they reached a first of its kind settlement with an AI healthcare company over deceptive claims about generative AI tools used in hospitals. As you can imagine, this is a particularly sensitive area when you're dealing with HIPAA-protected information, and AI that may be an open network sharing such HIPAA-protected information with other algorithms, tools, et cetera. So one of the lessons here is that UDAP statutes, which are often deliberately broad, give AGs a flexible tool to police misleading or harmful AI developments, even in the absence of new legislation. And we see certain states taking particularly aggressive action there as well. So while some states are taking the position that their UDAP laws as drafted already contemplate and account for any nefarious consumer protection activity conducted using AI, some states are actively amending their UDAP laws to anticipate these AI risks. I mentioned Pennsylvania, that's HB 1598. Utah also has a similarly worded statute, and basically it requires businesses to disclose use of AI to generate certain consumer content. So they want consumers to understand that they're dealing with an AI chatbot or that AI was used in the process. Interestingly enough, too, New York has proposed what they were calling the Fair Business Practices Act. So separate from the UDAP, but it would explicitly add prohibitions on unfair and, quote, abusive practices. That term abusive is somewhat new to the state UDAP context, if you will, but it mirrors the Federal Consumer Financial Protection Act's language, that abusive term. But I mention abusive because should this law pass, which I believe is currently sitting on the governor's desk, it would sort of open up a new line of analysis and interpretation that the courts would have to grapple with. What does abusive actually mean? So like I said, the CFPB sort of has some history there, but more to be drawn out in the state of New York and other states that are contemplating or analyzing that law should it pass. Some other changes that would come from this Fair Business Practices Act are applying these practices, including any sort of AI deceptive practices, in the business-to-business context. So some consumer protection state laws, some UDAP laws do contemplate B2B, business to business. Most of them obviously contemplate B2C, business to consumer actions. But if you zoom out a little bit, that's also important because not only are you trying to define what typically small businesses are what state AGs are interested in protecting most, but certainly that could expand to other businesses too, no matter the size or scope. So I want to talk a little bit about the substantive areas of concern that state AGs are focusing on. And so, as you can imagine, deceptive marketing of AI products, so exaggerated claims about the accuracy, the reliability, or for instance, like neuroscience validated benefits can fall squarely within deceptive practices. Like I noted earlier, I have noticed a very deep disconnect between the in-house team in many of our clients and their business client. And so I think I'm up on time. So I'll quickly just list out the rest of the areas because I'm sure we're going to have an opportunity to talk through them. But bias and algorithmic discrimination, sort of in employment, housing, things like that, deepfakes and digital replicas, transparency and disclosure, protecting children and adolescents, particularly in the chatbot relationship type apps. There are a number of children who unfortunately have taken their lives because of these sycophantic AI chatbots that mirror personal relationships. And so state AGs have their, especially Democratic state AGs, have their thumb on this very, very closely. And we're seeing more tort litigation coupled with UDAP issues on those AI tools. And then privacy and data security as well. So yeah, I will wrap up with that.
Thank you, Tiffany. Tiffany and Karen are somewhat ideologically aligned, and so are Christine and Douglas. We're going to switch to Christine, so a little bit out of order here. Go ahead, Christine.
Yes, hi. I am very glad to be here, sitting here in front of you to talk about consumer protection. I am a consumer advocate, non-practicing lawyer. I did 2 years. That was enough for me. So I am a consumer advocate, and I am going to sound like one. Unapologetically so. So so I'm going to just give it, what I'll say is, let's say there was an earthquake. I think in consumer protection, we're seeing a tsunami. That's where we are, I think, on every side of consumer protection. We are experiencing a tsunami in terms of the developments. But I want to start with one piece of information just to provide context of where consumers are, because that's who I feel I'm speaking for right now, sitting here. One is, I was looking at the Legal Services LSC, Legal Services Corporation, and some of their data, their recent data in 2022. They do an annual report, and they do these fantastic research reports on their community and also what low-income families. And the last one came out, the really significant one came out in 2022. I think they're going to have another one coming out in 2026 on access to justice, specifically low-income families' access to attorneys when they have problems. And some of the data from that is, and I really want to emphasize it, is that right now, 92% of low-income Americans did not receive help on a legal problem that they had. So low-income Americans, we know that there are millions of them, 92% of them did not receive help. And 50% of those problems, 50% of them were consumer issues, which is separate from housing, which is separate from family law, and other issues that low-income families face. 50% are consumer issues. So I wanted to start there. So there's a tremendous access to justice gap. And as senior policy director for NACA, which is an organization of consumer attorneys, there are not enough consumer attorneys because the data speaks for itself. So when I think about consumer protection, I do a lot of my work, a lot of consumer law is financial services based and also contract based. And so the Consumer Financial Protection Bureau, I started in consumer advocacy in 2008. What happened in 2008? That's when I started my career in consumer advocacy. And the Bureau was created by Dodd-Frank Act after the financial crisis. And so this year, so the CFPB has just been a major part of everything I've done. And this year has been tremendously awful for the Bureau and for consumers in terms of work being done on consumers' behalf. So based on a report of a former staff, or the former enforcement director at the CFPB, there are 22 enforcement actions that were dropped in the since February. 22 plus enforcement actions dropped and settlements reversed. So that is, I think they had calculated that was worth $360 million for hundreds of thousands of consumers across the country. These are real people that have been harmed, cheated, defrauded, ripped off by sophisticated or not sophisticated parties. So the Bureau has had that type of experience over the last, and it hasn't been just within the CFPB, it's also been, in the courts, there are a couple of CFPB rules have been reversed as well. And also in Congress. Congress used the Congressional Review Act to undo two rules, one on medical debt credit reporting. So basically there was a rule, that was, a court did that. A court undid that rule. This one, the CRAs, they undid an overdraft fee rule. So the CFPB had issued a rule to put a cap on overdraft fees. And that was CRA'd, which is the language, to kill that rule. And then the Bureau, as it is authorized to do, also issued a rule to supervise the non-payment digital providers. We know that is a big growing area right now, non-payment digital, non-bank digital providers, a large and growing industry or sector. And so the CFPB issued a rule that said, okay, for the large companies who issue 50 million transactions, that means a very large company, we are going to start supervising you under the Consumer Financial Protection Act. And the Congress undid that rule. One last, I think, I'm going to take it as a positive note about the changes there. One is the guidance document. So the Bureau issued guidance documents basically interpreting and reasoning and reaching conclusions about different issues that it faces. So it might face issues on the FDCPA, questions that arise, they'll answer, they'll look at it, the lawyers there will reason and reach a conclusion about how the law is to be interpreted. And the guidance documents, there was a notice that the guidance documents were withdrawn. So that's not the good news. The good news is the guidance documents were withdrawn without reasoning. So the reasoning still holds up. The reasoning still holds up in a court. The reasoning that they have provided in each of these guidance documents to say, this is why this law should be interpreted in this way for this reason, citing this case and this case, the CFPB provided those. They are still there. They still exist in cyberspace. They still exist on the internet, and their general counsel had issued a compendium of the guidance documents. And so, to me, as a consumer advocate, reading these, they are persuasive and are still persuasive in a courtroom. I will run quickly by because first, the second thing is I'd like to talk about is the UDAP laws. Thank you for talking about the New York law. I think that what's been happening with the New York law on UDAP, New York finally put the U in UDAP by adding unfair and adding abusive practices, and we're very pleased about that. The governor should sign it at some point, but that is some progress for the governor and for New York to add those components, even though it wasn't perfect. The next, I can't believe there are only 3 minutes left, but what I really wanted to emphasize too was the idea of the proliferation of abusive contract terms. Now, we all know that, adhesion contracts exist, what are we gonna do? They exist, let's just live with it, and I just don't think that we should. They are a part of, if we're talking about, the topic is developments in private enforcement, our private enforcement is in the consumer contract. It's called deleting our rights, our ability to privately enforce laws are in consumer contracts. And I recommended a reading for today. I'm sorry, it was more than 10 pages, but it's really easy to get through. It's a study, but that was released. The final was released in January of this year by a professor. And, she went through some of the, every single sector and looked at some of the most abusive contract terms that exist. And on top of everything else that we know about how consumer protection might be contracting on the federal level, that the states, while some are doing their best, that they lack the resources. This component of contract terms is also, I think, is just underrated, and it's not being, the idea of unconscionability really should be tightened. Some of the terms should be prohibited, and I can talk about those as well. But this idea of what's going on with consumer contracts and how it's not just about the price and the product, but how sophisticated it is in deleting our rights is something that it keeps developing. The consumer contracts are getting more sophisticated each day, and I guess generally the public is fairly helpless about how to go about attacking that. So I will end there. Thank you.
Thank you, Christine. Karen, why don't you take it away?
Yes, thank you all for sticking with us today. As the judge mentioned, I do have a background with small business. I ran the Legal Center for NFIB for 20 years, a small business advocacy group. And in my current role, one of my ventures, if you will, is I'm executive director of the Center for Constitutional Responsibility. And the two intertwine in that, we, as a small business advocate, I have seen up close and personal how the effort to, I guess, for lack of a better word, say, do good and through litigation and driving the law forward can also lead to a lot of frivolous litigation and that sort of thing. And also, more importantly, for what I'm going to talk about today, unaccountability. And so what we have seen over the last, let me back up. So there are a number of statutes, not just a number, there are thousands, over 3,000, it's been documented in the states. And then we have a number at the federal level that allow for private attorneys general, allow for citizen enforcement. And this isn't just private right of actions, which I know a lot of, I'm not necessarily always a fan of, but this is more pernicious because these are deputizing the citizenry to stand in the shoes of the executive, whether it's the president or the governor. And what we have seen is rather than pulling back on many of these laws, of which I'll get into examples in a minute, we are seeing an expansion of them. And it's I'm here to tell you why that's a bad idea and what you should be looking for, because these lawsuits continue to come up with people using these laws to, make law and enrich themselves. But these laws allow citizens, they allow groups to step in the shoes of attorneys general at the state and federal level to enforce the laws. Sometimes, like the False Claims Act, which some of you may have had experience with, there's actually an incentive to do this. There's a whole group of people that are called relators that receive an incentive for bringing these lawsuits. And you've seen in a case that was decided 3 terms ago by the Supreme Court, where the interest between the government and these relators start diverging, which also shows the problems with these laws. Because in this case, Polanski, the government had decided, the False Claims Act is used to sort out fraud in the government, and Medicare space is most commonly used. That's a good thing. But the relators will get 30% if they are able to successfully prosecute these all the way forward. And in this Polanski case, the government had decided, you know what, the juice isn't worth the squeeze on this one. For whatever reason, they wanted to dismiss the case. But the relator went ahead and said, no, we want to go forward. Well, why? Because they're going to make money. They're going to be enriched financially if they do so. And the Supreme Court decided, fortunately, that the government drives the train. And as a result, they can dismiss the lawsuit and it can all go away regardless of what the relator is wanting. And I think that is a great example of what really should be happening here, because what we are seeing, as I referenced earlier, is an expansion of these laws. You may be familiar now with the Texas abortion law that was enacted, I guess, 4 years ago. It literally says in the statute, black and white, that the law is only to be enforced by the citizens, that no state government official or city official can enforce this law. So we now have a situation in Texas where citizens can enforce laws against other citizens, which in this divided world in which we live, I would argue is not such a great idea. Well, not surprisingly, when this happened, California looked at this model and said, well, let's do that on guns. So now we have a law in California that is similarly enforced against citizen on gun issues. And we've had these laws on the books in addition to the False Claims Act. You see this in the Clean Water Act, citizen enforcement there. Clean Air Act, citizen enforcement there. California's Prop 65 is notorious for that. Anybody that's had the pleasure or not so much litigating there is very much used by that example. Their Private Attorneys General Act similarly was created to have this citizen enforcement. While modifications and reforms have been made just last year to that law in an attempt to get rid of some of the abuses that come from it, my understanding from practitioners on the ground is that as a practical matter, the bottom line number is staying the same when companies are having to settle. So it's not necessarily making the difference that had been hoped for. And then finally, we are seeing consumer advocate groups and environmental groups and others using these laws. Most recently, my organization, the Center for Constitutional Responsibility, went in to talk about the constitutional flaws we believe that exist in the DC's Consumer Protection Act, for example, in which it allows groups like the Environmental Working Group, who sued Tyson's Foods, alleging greenwashing, which is a practice that is alleged when a company is claiming to be acting, environmentally responsible, whether it's net zero emissions or whatever the claim might be, and then the group is saying that they did not. All of these laws, though, are being brought, or all these lawsuits in many instances, and actually I would posit in most, are not being brought on behalf of a specifically injured party. In fact, sometimes there is no injured party at all. And I would argue that's more often than not, and that's part of the problem. There are real constitutional questions that I think you all need to be considering when confronted with this type of enforcement mechanism. Under the federal Constitution, it's very clear. The executive is vested with the power to enforce the laws. The Take Care Clause gives the president the authority to make sure that the laws are faithfully executed. And then you have the Appointments Clause, which directs that, only people that are appointed by the president, confirmed in many instances by the Senate, can act on behalf of the executive. And this last point was the piece of Judge Mizell's opinion that came out. She's a district court judge out of Florida that recently, or I guess actually it's been a year now, ruled that the False Claims Act she felt was unconstitutional and for this very reason. And that is now being considered by the 11th Circuit Court of Appeals. It looks like briefing's going to conclude by the end of the year. But that's a real big one because Justice Thomas has been very skeptical of this kind of enforcement mechanism for years, has raised this as a concern. Polanski's concurrence is very much worth looking at from 3 terms ago. In addition to the constitutional flaws, there's a lack of accountability. Private plaintiffs, everything, they're a hammer and everything else is a nail. They are only, aligned with themselves, not the general citizenry. It opens the door to targeting people based on ideology. It undermines the reliance on the bigger picture lens in which the executive at the federal and the state level is going to be able to look at enforcement and be able to distinguish between, not that anybody should be, opposing, not obeying a law, but there are gradations of legality and also what's worse than others and having that bigger picture instead of every little gnat being treated the exact same. And then finally, again, the citizens just don't have a way of holding the people accountable for what they're seeing with these laws. Let me move on to, I guess what I would just say is we are seeing more and more, and I think this has been mentioned by both Tiffany and Christine, Congress's lack of inaction is also being brought out by this, right? Because you have environmental groups or activist groups or other ideological-based groups on the right, for example. It's not just abortion. Texas loves doing this now. They are looking at it or not just Texas, I don't mean to just pick on them, but it's not just one party. This is a bipartisan issue. ESGs, going after companies on DEI. Hermit Dillon, our current civil attorney general in charge of civil rights, has encouraged people to bring False Claims Act challenges against companies in the effort of clamping down on DEI. Regardless of what you think on these issues, and of course I have my opinions just like everybody else, the bottom line I want you to consider is when faced with these statutes at the state level, at the federal level, that you think about what this means for the constitutional structure, what enforcement is supposed to look like, and how it more properly holds, people are more able to hold people to account if it's not citizen on citizen litigation, and worse when they're incentivized to do so. And with that, I am concluded.
Thank you, Karen. Douglas.
So I have been doing a consumer protection law for about 30 years now. I did it in the beginning on the defense side and then moved over to the plaintiff side. So while I have probably a similar view as Christine on many things, both having been on the defense side and also seeing some of my colleagues file suits that make me just cringe, I am a lot more, I'll say it, cynical about some of the lawsuits that the plaintiffs bar bring. So I'm not as ideological about it. However, what I am aware of is that nature abhors a vacuum, as do plaintiffs' lawyers. If the CFPB goes away, we will move in. If the EPA stops regulating greenhouse gases, we're going to sue. If you're going to take away the incentives in false claims, we already have an incentive. It's going to be a contingency fee, and we're going to get it. Maybe we won't get 30% of the total proceeds. We'll still get something. A lot of you're seeing right now is a reaction to an absolute abandonment of consumer protection by the executive right now. The CFP, I mean, the 22 actions that Christine mentioned, but also the FTC has basically decided it doesn't really care too much about what might be abusive practices. So I will say this, we're busy and we're getting a lot of resumes. What I wanted to focus on also is what some of you may be seeing a lot more soon in your state courts. A couple of years ago, in a case called TransUnion versus Ramirez, Article 3 was front and center about whether or not folks who's had an FRCA report that wrongly called them terrorists by TransUnion, whether they had standing in their class action to get damages. The Supreme Court basically split the baby, and they said the 1,850 whose report had actually been disseminated, well, they had standing, because under common law precedents, this is akin to a defamation. The other 6,000 plus whose report may never have left the office and no one had ever looked at, they did not have standing. It was thought that, well, this is going to, no concrete injury, no standing, this is going to have a big effect on consumer practice. I do a lot of data breach cases. We were very scared of that case. It hasn't proved to be a problem in data breach cases that much. But in other cases, it has been a launching ground for other arguments. But one of the notes, dissents in TransUnion was actually Justice Thomas, who had a very different view of standing and thought the concrete harm thing, which came only about 7 years ago, was kind of just made up recently and didn't deserve the credit that it had been giving. But he noted in a footnote that TransUnion's victory may have been Pyrrhic because, the old careful what you pray for. If you convince folks that you need Article 3 standing in all these cases and you're an uninjured class member, the result isn't that, corporation, the class goes away. They're going to do it in state court. And that may be where you're going to see a lot more class actions, in state court. In my last two car cases I had, one in front of the 8th Circuit and one in front of the 6th Circuit, the defendant argued that because not everybody's vehicle had suffered the injury, not every class member had standing, and therefore the case could not be certified. The 8th Circuit agreed with that argument. The 6th Circuit just recently decided to sidestep it, and they killed me on predominance grounds. But they did sort of recognize, the 6th Circuit did, that if you bought a vehicle that has a design defect, well, that would seem to go to its price. You should be able to have standing, but we're not going to reach it right now. We don't have to. This came on the heels of the LabCorp versus Harris case, one of those statutes which, my God, does that statute get abused. That is a statute that meant well, but man, there is a whole lot of shakedowns related to that statute. It had to do with, folks will go through and see if somebody maybe theoretically discriminating against people who are visually impaired. They found a kiosk, they filed a suit against LabCorp. The facts, quite frankly, stink. It's one of those where you see the Supreme Court takes it up as a consumer practitioner and you're like, dear God, please don't let this be the basis to kill class actions and end my career. Fortunately, there was a change in the class definition, actually as pointed out by my colleagues, and the Supreme Court dismissed it as improvidently granted. But Justice Kavanaugh made clear in his single dissent, unless everybody's injured, as far as I'm concerned, you don't have Rule 23 met. If there's any uninjured class members in it, you don't have a class. Again, that is more incentive for practitioners like myself to start looking at CAFA, start looking at the home rule exclusion, start looking at suing defendants only in their home states, and doing smaller class actions that stay in state court, so we do not have to worry about Article 3. On that, let me talk about a couple of statutes which I'm quite fond of in that way. In California, they introduced something a few years ago called the CCPA, the California Consumer Privacy Act. What that does is, in data breach cases, it, in addition to basically setting out a pretty basic standard of care, it has statutory damages. A little later, California came out with the CMIA, which is if medical information is wrongly shared or stolen. These are statutes which are very amenable to class actions. They do not require differences. You don't have to worry about any differences in injury. Was the data used for to open up a fake account to get a tax credit, to create a false identity? It doesn't matter. You failed to adhere to the standards. Therefore, you're on the hook. Therefore, you have to pay money. It creates the incentives to go ahead and file that case, but also creates a way to get that class done rather cheaply. I have been doing this for 30 years. Damages models are the most expensive part of my job, of coming up with ways to figure out how to get everyone paid, and it got even more complex after Comcast. So having statutes with statutory remedies are a flashing light, and like a moth, I'm going to go there. And I am going to file that case because that is one where I can actually make sure that I can get paid and get my client paid, and don't have to worry about paying Mira, Cornerstone, or some other outfit hundreds of thousands of dollars to come up with a model. The last part I just wanted to, and it was reminded me about going back to what Justice Thomas mentioned in TransUnion, careful what you pray for. If you are a business advocate and you are opposing federal statutes, say on data breach, which has been the problem. I've looked at many proposed federal data breach statutes that would preempt California and others, but would have a private right of action and a statutory damage remedy, and it can't get passed because one side says no way in hell, and then there's also folks on my side who say we don't want the CCPA ruined. But if you come up with an actual federal statute that preempted, gave businesses one standard, but also makes clear you're going to have to pay if you don't meet it. You can't just run away and say Article 3, or you can't run away and say individualized damages. You're going to end up with this balkanization of consumer protection law, and that's a lot of what's happening now in data privacy. It's going to happen with AI. It's going to happen with a lot of this. And be careful what you ask for, because if you're going to get that, you're going to find some states, you're going to have an Illinois statute, you're going to have a California statute that are going to hit you very hard if you're a business and you don't meet the standard, and you can't really plan for it. Whereas if you had a national program, you might be able to negotiate it better. CAFA got passed over the objection of a lot of folks like myself, because there were some states that were more favorable than others than class. Well, if you end up succeeding in making Article 3 and having uninjured class members death to a 23B3 class and preclusive of getting damages, it's going to go right back to states. And you're going to end up again with a balkanization. You're going to end up again with different states being more favorable than others, and you're going to have to contend with that. And if you want a bill of peace, which I can say, having been on both sides and done this for decades, is almost always what the defendants want. They're all frivolous, they're all terrible, they're all bad class actions. Can we settle it one place? I mean, I missed the arbitration thing yesterday, but I can tell you that arbitration thing has not worked out like Mr. Pincus and all the folks thought it was going to. It has backfired dramatically because all of a sudden those ARB clauses become a vulnerability because of mass arbitrations, because the cost for that, and then even if you resolve a lot of that in mass arbitrations, you get no precedential value and you get no bill of peace. So again, if there is a vacuum, we will fill it. If there are changes done to make it harder for plaintiffs, we'll try to figure out a new way. You got to figure out some way of doing this if you're on the defense side, if you're on the corporate side, that's going to recognize the easiest and best way for everyone is almost like the ALI approach, talk through it and come up with a consensus that will actually be fair for everyone so that you're not going to end up with an absolute lottery ticket of a tort system and a consumer protection system. Thanks.
Thank you, Douglas. You know, I heard two sort of discrete areas that I found somewhat interesting. One relating to AI and the second relating to private rights. So let me just throw this out to the panel. You know, with AI, you know, the lending, insurance, hiring practices, I think what Tiffany referred to as, you know, algorithmic outcomes. I'm wondering any thoughts on, you know, what can be done to prohibit discriminatory outcomes there or discriminatory practices when AI is feeding this data in there and these really significant life-changing types of decisions are being generated by AI. That's one area. And the second area that struck me with respect to some of the things that Karen was mentioning on private right action, and Douglas sort of hit on it on abandonment, is, you know, what if a state or the federal government really decides not to engage and enforce law? And it strikes me that, in a sense, you are compromising law-abiding businesses, putting them at a competitive disadvantage unless there really is a private right action. So with respect to those two topics, I'm curious to some of your thoughts on those.
I'll start. I'll be very brief on the AI's response, but I think that in regards to AI, that I think AI probably needs a very focused law, but I will say that with the UDAP laws and also with other outlaws like the Electronic Fund Transfer Act, I mean, there is a slew of long-standing federal and state consumer protection laws that can apply to AI practices. There's a reason why it's unfair, deceptive, abusive, which is, you know, another term that are in state laws, and which last year the CFPB had defined abusive in terms of applying it to its enforcement actions and to financial institutions' behavior. So I think with AI, while there might be elements, particularly with the discriminatory practices, even though there are civil rights laws as well, that long-standing consumer protection laws should be vigorously applied and vigorously enforced to ensure that it's being applied. I don't know the proper term for how AI is kind of taking over the world, but that it is treating consumers in a fair manner.
Tiffany, any comment?
Yeah, I think that's right. I don't really have much to add by way of sort of the statutory recommendations. I think Christine is right. I think, again, from the perspective of, I'll counsel our clients sometimes before they receive a complaint, which I always love because I think it's great that we can try to keep companies out of the courts. But I think I just underscore the same idea as really understanding what your business is doing with AI to understand where the potential discriminatory practices can come up. So education, asking the right questions is really important, but I think laws like some of the transparency laws that we've talked about, where businesses are required to disclose that the consumer is interfacing with AI, is a good start, because at least the consumer can sort of self-monitor in a way and say, okay, I've heard some things about AI, I now am entering in private information like a social security number, maybe I should sort of pause there. But I think it just requires, the technology has just moved so fast and we aren't understanding exactly what it's doing just yet. But I think there really is an importance on educating our clients too on where the potential pitfalls are.
On the private right of action piece, I would just say that, you know, I'm a purist on this one. I just think that if a state or federal government isn't enforcing the law, the citizens are going to notice that. And I would like to think that the groups, many of them that are bringing these types of suits and trying to stand in the shoes of the executive, could be using their time to make that known to the citizens, to the voters. Because otherwise, really what we're seeing again is In California, there are a number of these lawsuits, again, using Prop 65 and PAGA against companies that there's really, it's not even, there's really nobody they're identifying. It's just the general public generally is not, is suffering under this. The same with this DC law that I mentioned earlier, their Consumer Protection Act and Environmental Working Groups lawsuit there. I think that it's better to be raising awareness and having people know, okay, these laws aren't being enforced to the extent. But many of the claims that are brought under this, if I'm being completely honest, are just out to, it appears to continue to feed the beast, continue to feed the whole lawsuit, the people that are bringing the lawsuits and their organizations. This is not a situation where you have even the class action model where there are people that are going to have to prove that they were actually injured. In many instances, this is just people stepping in the shoes, again, of the executive to enforce laws. And I think that muddies the waters when the public can't see that laws are not being enforced. I think that is something that needs to be voted on rather than people taking it into their own hands.
Two things. One, just when you mentioned about, AI and discrimination, I remember the Real Page case, which is, there's been a bunch of them going now. Real Page was using an algorithm for pricing, which, whether they meant to or not, was clearly discriminating against people of color. And there have been a number of suits against Real Page over that, using the existing laws. Because they can claim whatever the basis for the algorithm is. If it comes out and it's discriminating, then it's unlawful under most of the state's UDAP laws or discrimination laws. On the private right of action, there is the private right of action where I'm suing because I've been injured, or I'm suing because, the water's not clean, and I have no standing otherwise. I'm just suing as a pure citizen who thinks the water's a mess. If you have a state where, say they're not, let me give two different examples. That example there of the group that's a WWF or a Clean Air group or some kind of Sierra Club that is just basically focusing on environmental protection, they are getting paid by folks who are giving them money to do that. They are getting dues for folks to do that, and they do have standing requirements even under Lujano and the other cases. So it's not a free rein. There has to be some kind of rationality to it. At least we'll see what happens this term. I think that might change. But on the other ones, one thing that struck me recently is I had a case where we have an Arkansas Consumer Protection Act claim, and it was certified for a class, and the defendants pointed out that the statute is written in a way that you can't have a class action. That was the case, but the 11th Circuit said, well, it's a procedural thing, and following the Stevens opinion in Shady Grove, that was procedural. You could still have a class action under Rule 23 if you're bringing it in federal court. Well, the Arkansas legislature and governor, after that, decided, oh, no, it's not procedural. We really, really don't want our consumers to be able to sue out-of-state corporations that may harm them in a class way. Now, as a voter in Arkansas, I'd be like, what the hell are you doing for me? Are you interested in me at all? But fortunately, I don't live in Arkansas. I live in Virginia, and I have an election coming up, and I know who I'm voting for, and I know what I'm going to do to the Virginia Consumer Protection Act. What I'm going to do in November if things change. I'm going to make sure that my Virginia Consumer Protection Act doesn't have that language in it, which has the exact same language. So I agree with Karen. The voters should know about this. I also recognize that sometimes elections don't go the way people want because there's out-of-state forces that lead to voters voting against their own interests.
We'll open it up for questions now, so please fire away, come up to the microphones. Don't all rush at once. While we're waiting, I'll just, Karen, I have a question for you. Of course, everybody read the materials, I am sure. Karen had some fine pieces in there, and one of them talked about the proliferation of the right, private right of action laws. Many states are empowering their citizens to bring suits statutorily. And when you mentioned that, look, if there's non-enforcement, hey, it's up to the voters. But in the democratic system, haven't the voters spoken in many of these states to allow private rights of action?
That is a good point, and I would just say that, I still think fundamentally that goes against definitely the federal structure of our Constitution and the thought of the executive being in charge of enforcement. And in most state constitutions, it's the exact same way. And that is one of the things we're trying to do, is also raise awareness of this, because it really does create a divided society where we've got each other knocking on our neighbors to enforce laws. Another area, when we talk about the red states that are doing this, we're seeing it with some of these new social media laws. Although well-intentioned, anybody can step in the shoes again. You're looking and seeing that really anybody can bring these lawsuits, not just the parent of somebody that was harmed by, an app or some interaction with the internet. And I really believe that it's just critical that we get the benefit of the executive and their big picture enforcement, and you can see, so that you're not going after gnats, that you're not treating everybody the same. There is distinction there, and I am hopeful, honestly. The False Claims Act is one to watch. That's the 11th Circuit, as I mentioned. There's, I think, another challenge to the False Claims Act. One of the pieces I did submit, not just Thomas, but Barrett and Kavanaugh have expressed skepticism with this sort of enforcement idea. And so I am hopeful that we can bring some of this down, because I just think that we need to restore the separation of powers and the balance that was meant, where Congress is writing the laws, the executive is enforcing them. And if you don't like it as a citizen, you can vote for a change. But I will say, to your point, before I conclude, that in my conversations with some folks in Texas, that was part of the reason they did the abortion, because they were worried that certain jurisdictions within Texas would not enforce the abortion law if they had not given enforcement to the citizens. That's an issue too, but that issue has been resolved in places like Iowa, where if they don't like what a district attorney is doing there, by not enforcing a law, the AG can step in the shoes. There are other ways, I guess, to skin that cat that don't involve citizens being unleashed against each other for the public good through litigation.
Christine?
Yes, I haven't had the opportunity to talk about private enforcement that much, but I'm going to say the most obvious thing, and the most overlooked item, and that is the Seventh Amendment. I mean, the Seventh Amendment is on the same level as the Second Amendment, in that it's an amendment. Which is the right to a civil jury trial. And I felt like it needed to be said. That is one amendment that can be waived in contracts, waived over and over and over again in contracts. I want to say that, that our founders thought that it was a critical part of what would make this country. And that sounds over the top, but it is not treated the same as other amendments, not even the First Amendment, which is, more recently an issue for all of us. And I think that, it would be great if the Seventh Amendment received that's a similar type of respect.
May I add a comment as well? So maybe I'm taking off my private sector defense side hat right now, but based on some of the things that Christina shared and others, and I was recently at the Democratic Attorneys General Association conference in Denver about a week and a half ago, and this was access to justice and access to the courts was a topic that came up there as well. And since I have a captive audience, and this is an important issue, again, personally, but I think just in general, Christina's completely right, obviously, that we've seen folks are scared to go to courts for pretty well-publicized reasons, including ICE raids. So there are significant decreases in just the number of folks who will show up to court. So that means they're not advocating for themselves. And then add to that, our job is hard for a reason. We speak legalese, and this is not accessible to many people. I don't think I'm preaching to the choir, but there are ways, and this is some of the things that were discussed at this panel in Denver, there are ways for technology to help walk the average citizen or resident through what it takes to file a simple landlord-tenant dispute, for instance. And there are some state courts that are doing this across the country because folks are afraid of physically showing up in person, or they don't have access financially or for other reasons to lawyers. So that 92% statistic that you've cited to, Christine, I think really resonated with me in light of this discussion that I heard recently. But then maybe putting back on the hat of being at a big law firm, a lot of law firms are scared to take on these types of cases, given some of the recent actions that have taken place against big law firms. I feel very fortunate that I'm at a firm that has stood its ground as far as the type of pro bono cases we'll take, but we have a lot of organizations coming to our pro bono partners saying, hey, we need more. We need firms to take on more because we don't have the resources as a nonprofit. And a lot of firms have turned away for their own reasons, not to shame any firms for the business decisions that they've made. So it is an issue, and it just has been exacerbated given some of the step backs from big laws recently too.
We have a few more minutes, just last few minute each. Minute and a half each of you, go ahead.
I'd just like to say one other group, as we're talking to access to justice, one of the issues with these private enforcement models, whether it's private right of actions or private attorney general laws, is the people that really suffer the most are the small businesses that I've represented my entire life, because they do not have the wherewithal, the financial means to engage through the litigation. So, the Americans with Disabilities Act is a great example of this. Even the Telephone Communication Protection Act. You have seen rampant abuses with vexatious litigants that have been called out and sanctioned using these statutes to go against businesses. And that is just yet another issue, I think, that is presented by these types of laws and why they're problematic.
Okay, I had to skip over my whole UDAP section because I had so much to say, but I just, one point I wanted to share about UDAP and just the application of UDAP in recent cases, and that is door-to-door sales, and one of them being in solar panel sales and unfair deceptive practices there. It is growing it's a growing complaint with state attorneys general, with legal aid attorneys, with private consumer attorneys. It is, and the issue there's an e-sign act that, a person will show up, have an iPad, there's nothing on the iPad, but then a person may think that they just want to see if they qualify, and all of a sudden they've been signed up for 10 contracts, the financing, the loan, the contract with the contractor, and different agreements. And so, and that is another kind of abusive element with where contract law is going, and I just wanted to mention that. One is the bane of my existence, which is the abusive contract term, and with the unfair and deceptive practices and how that law is developing in the states. And thank you for listening.
So I was thinking, in regards to the Seventh Amendment, because the earlier panel was talking about the PLI and the consumer contract law. And, when I was a criminal practitioner at one point, and I learned a lot about voluntary and knowing and intelligent waiver of your constitutional rights. I could do that with my Fourth Amendment. I could do that with my Fifth and Sixth Amendment. But with the Seventh Amendment, the courts have accepted an absolute waiver of your rights with no voluntary, with no knowing, and no intelligent waiver, again and again and again. The Seventh Amendment has basically been relegated to, well, it's somewhere in the boilerplate. Maybe you had to get clicked on it. Everybody else does it. You can't necessarily vote with your feet. Like, I can't get a car. I tried. Every time I crossed out the arbitration clause, they won't let me leave the lot. I can't get a credit card. I can't get a phone. I, who spent all my days hating arbitration clauses and restrictions and class waivers, have to accept them because I can't vote with my feet. I can't make a voluntary knowing intelligent waiver. I have to accept it. Well, my hope is, as we develop contract law further, and we recognize that this is just completely unfair and one-sided, that these clauses just don't get enforced, that we recognize them for what they're worth. And I think a lot of you are going to see a lot more of this coming up because with everybody moving to now to arbitration clauses that won't even allow you to do mass arb clauses, that make it difficult to do that, or class waivers in every shape, form, and a whole lot of other hidden gems in the boilerplate. I think you'll see a lot more arguments about that as we try to preserve those access to justice.
I want to thank the panel. This is a very excellent job from some very well-informed, bright legal minds. So let's give them a hand.